in the area of prosecution, in the area of litigation, in the area of issues or incorporation of wildlife together with other corrupt areas. But I think the better way to start is to also remind us of where we were as a country and where we are today, and what the lawyers have been telling us, that look, law is a living thing. At the risk of being immodest, I think I stand to be corrected by researchers like Matthew and Co on Nigeria, is the fact that before 1999, there was virtually nothing like a formal anti-corruption in Nigeria. Nothing. There has not been any political office holder that has been tried in court and took less of it being successful in terms of prosecution. Nothing like that. There was no precedence whatsoever in terms of criminal prosecution in relation to corruption and other related issues in the country. But the first bill that was sent to the National Assembly on the return of democracy in 1999, was the bill to set up the ICPC, that is the Independent Corrupt Practices and Other Related Offences Commission. It was the first bill that was sent by the president. And that was what set the tone for, the formal anti-corruption efforts in Nigeria. And of course, I have to remind us of the fact that the Code of Conduct Bureau is a provision of the Constitution. The Constitution provided for the establishment of CCB as well as the CCT to try offenders of non-failure to or false declaration of assets as it relates to public servants. But then the same government from within this, with the same parliament, also sent another bill for the establishment of the EFCC, which clearly, is an indication of the fact that, look, there shouldn't be any conflict, for instance, just as Matthew is trying to, or the research is trying to say, in terms of conflict or overlap between what the EFCC is doing or what the ICPC is doing, because it's the same presidency, it's the same National Assembly, the Fourth Assembly, 1999 and 2003, that also passed the bill for the establishment of the EFCC. It is after the establishment of the EFCC, of course, and the ICPC, that we begin to test, the laws, and corrupt public officials were for the first time, taken to court. It has never happened before. And then, of course, with the old law, with the old system, we have to, trial and errors, as well as pushing for parliamentary amendments, etc., which is, of course, bringing us to where we are today. It was something new, it was something novel, but then it has to do with the sheer determination and courage of the founding fathers of this institution to be able to push through this against all odds and ensure that those trials have taken place. And then, of course, is some of the issues that we are battling with up till now. For instance, issues relating to delays in court. Fundamental human right of individuals is key. And the Constitution of the Federal Republic of Nigeria provides for fair hearing. You are innocent, until proven guilty. You are presumed to be innocent until proven guilty. And in as much as the trial is ongoing, you are an innocent person until otherwise. And the prosecution is expected to prove its case beyond reasonable doubt. And then thereafter, of course, you have the chance to come up and of course, put off your defense. Now, to start with that in mind, lawyers are exploring all sorts of things and all sorts of avenues, delay tactics in the name of fair hearing, which there is anything or nothing anybody can do about it. it's a fundamental human right. You are expected to prove your case beyond reason. Not that we don't have the case or this, but it's just what it is. Provisions of, for instance, let me tell you, the Evidence Act, which is the bedrock for tendering evidence in court, etc., etc. The Evidence Act that we have in Nigeria was the one that was handed over to us by the colonial masters since in the 1950s. Not until 2011 that it was amended. Why was it even amended in 2011? Because it is being tested in the court. So as far as there is a progress there, we have some lapses there still that we still feel that, we need to go back and say. What I'm trying to say with all these examples is that, look, we have made tremendous progress from where we are to where we are now. Are we perfect based on what we have now? Certainly not. There is no perfect system anywhere in the world. And when it comes to these issues of delays, one of the key things, it is beyond us. It is not that the cases are not good. It is not that there is no much synergy between the prosecution and the investigators. But the court processes itself. In a situation whereby you have a judge that have 500 to 700 cases in his docket because of the inefficient number of judges within a particular court jurisdiction. What are you going to do? And he has to listen to all the cases. So the provision of which I will come to later on, for instance, when we try to address the problems of delay in court by encouraging the parliament to have the amendment of the procedural laws of the country, that is the AJA 2015, and we made provision in there that, look, there should be a day-to-day trial of cases. Yes, the provision is there for the judges to follow, but it's practically impossible for them to do that because we have, a very limited number of judges to listen to these cases, and the cases are increasing by the day. So it's something that the government is aware of. It's something that we are aware of. It has to do with budgetary provision. It has to do with a lot of other logistical challenges, etc., with a limited budget to come and deal with those issues. So I keep on saying this, even during my Senate confirmation, and there's nobody that have come to tell me that my statistics is wrong when I said that the EFCC is having 98% success rate in court, irrespective of what Matthew was trying to cause division, which I will come to later on. How do you put it, Matthew? You were mentioning the big fish and small fish. It is all within our mandate to deal with the big fish and the small fish. But irrespective of the nature of the case, whether it is for big fish or small fish, we have 98% success rate in court. Irrespective of that, despite all the problems. Matthew, you are aware of, for instance, the former governor of Abia State, for instance. It took us 12 years to get him prosecuted. 12 years. And we had to go to Supreme Court 3 times. Eventually, he was convicted. Now, it's very important that I highlight this point here. Why? Because we had a problem in which you would see cases being handled by a certain judge, and all of a sudden he will be elevated to the Court of Appeal. And then we have to start de novo all over again. Now, based on that problem, we push for the provision in AJA, which is the Administration of Criminal Justice Law, that when you are elevated, you are expected to come back. You can still be called upon to come and conclude cases that you have. Now, we had this problem with the governor of Abia State. The judge was elevated. And ironically, it was at the instance of even the defense. They pleaded that let him come back by this provision of the law to come and conclude the case, which of course we agree because of course we are on the verge of doing that. And then he came back from the Court of Appeal, sat on the case and got him convicted. Only for them again to now push to say that, look, there are divisions of courts in Nigeria as provided for in the Constitution, that the Court of Appeal judge cannot come and sit on the bench of the Federal High Court to give evidence. And they pushed the matter all the way to the Supreme Court. And the Supreme Court agreed with them. And that provision of AJA was more or less expunged. And what do we do? That means he was set a free man. Now we have to start all over again at the Federal High Court. We are on the verge of filing the matter again. And then all of a sudden you will hear the media saying that EFCC, we never lost that case, for instance. He was convicted based on the evidence that we push. Now, by and large, again, all these issues are there. The law is a living thing. We are testing the laws. We are working tirelessly in terms of that. There is that synergy, as I said. Nick was mentioning some of his experience regarding pre-executive advice, etc., etc. We do that, Nick, back and forth. Only that at times it's difficult for you to come out and mention your modus operandi to the public, regarding how you come about some of these issues, etc., etc. Now, lawyers are with us in the EFCC, for instance. EFCC, Nick, and other audience, we have the biggest chamber in Nigeria. If you have to call it a chamber, we have the biggest chamber in the country. Because as of today, as I speak with you, I have 205 lawyers or prosecutors across the Federation. And I'm even thinking of recruiting more. But God willing, we're going to recruit more than 100 before the end of the year. Because, of course, that is the way to go. We always think, Nick, that, look, for every case that you have your mindset that you are going to the court. There is no doubt about it. You just have to go to the court. But some of these delays, I can talk about this issue for the 15 minutes that you have given me, personally as a practitioner. But I can't help without telling you this story, Nick, and other audience in terms of these delays. It's like a drama in court in the name of fair hearing. We still need to improve on that. Other jurisdictions like in the UK, etc., they have case conferences even on criminal matters where some things are being weeded out. But because we are using the old laws in the country up till now, you have to dramatize. Could you imagine, Nick and Matthew? I was in court the last time I was in court. I'm still going back immediately after the strike. You have to dramatize. I was to tender a document, a letter written by the EFCC to the Corporate Affairs Commission, which is the company registration outfit. And this is the challenge. We know the challenges. We know what the problems are. And God willing, based on what we have, the engagement we are having with the executive, with the parliament, etc., we will get there. In essence, give you the history behind saying that we started in 1999 is just to tell you that we're just 21-year-old in the field, and we have made tremendous, progress in that. But I won't conclude with some of the issues that Nick have raised without mentioning the issue of plea bargain. Plea bargain, long before there were made provisions in ADJA, we have been using it in our own way in the EFCC. But now that it is there in our statutes, we have been using it tremendously. In fact, one of the things that is ongoing now is that the Office of the Attorney General of the Federation is trying to come up with administrative guidelines, on the utilization of plea bargain, which will be a document that all prosecutorial agencies will be guided, by. Majority of the provisions there, are things that the EFCC have tested in court, but we are now trying to take it national. I don't know whether I have mentioned or have said one or two things regarding what we are doing. We have been accused of, for instance, having hundreds or thousands of charges in court, and as a result of that, we had series of delays, etc. And the court cannot give you what you did not ask for. When you have, for instance, a former governor that has ruled his state for 8 years, he had done multiple of transactions, for instance, to personally enrich himself. He has bought houses in Europe, in Dubai, in Nigeria. If you do not have count charges on all those issues, there is no way you can take away the process of crime from him. So 100 transactions, 100 count charges. But we are determined going forward. We are trying to change our policy drive on that. We are keen now. What I instructed our prosecutors to do is that we will take one issue, and then we will have 2, 3, 5 counts around that issue. And then we'll get you prosecuted on that. We'll ensure that you are in prison. Then while you are in prison, we'll be bringing you to answer to the other charges, maybe the 1999. Then go ahead and continue to delay while you are still serving the prison term. Because we realized that, look, irrespective of the multiple number of counts that you have, the sentencing, the prison term is going to run concurrently. So we said that, look, we want to avoid all these delays. We want to avoid all these issues. We'll take one issue. Maybe you bought a house in London, for instance. We'll build our charges around it, conspiracy, obtaining by false pretense, money laundering, regarding that property. Deal with it, shout on it, and then while you are in prison, cooling off, then we'll now file other charges, against you, and then we'll move on. We have not started testing the new directive, but I want to assure you that that is the way to go, and I have already given the instruction, and everybody is happy within the system about it. I believe it will not leak to the press that this is what the EFCC is planning to do. Jihad, if I can have your words.